at the topic, protecting your creativity while registering your intellectual property is key. So intellectual property is one of those very wide and diverse areas of law, which, you know, encompass different facets. And it's very important for creatives, whether they're upcoming creatives or they're established. One of the problems, however, is that creatives are still not catching on too much to why there's, you know, you should protect the intellectual property. There's so many immense benefits of it. And in this kind of era where, you know, it's very fast paced and, you know, your products and services are not only open to a smaller Jamaican market or even a Caribbean market, but really open to the world at large. Creatives must protect their intellectual property because they've spent all this time, it's the fruit of their labor. And sometimes creatives actually depend on their creations, you know, as a source of income, as their lifeblood, and therefore intellectual property assets could actually be the most valuable asset to a creative. So how a creative views intellectual property can either make or break them. You know, where your renown, how well people know you is based on, you know, you getting your work out into the public for people to see. It is important then that you do not leave your work exposed so that people, unscrupulous people, might be able to take advantage of that work without any recourse. Now, when creatives create, you know, content, it may be of a proprietary nature and therefore it should be protected. You know, when you spend all this time, you know, lots of time and huge amounts of money in creating your work, whether they be novels or, you know, you spend lots of, you know, money on equipment so you can take your photographs, you really want to reap the benefits of this and take advantage of the consequential property rights. It is possible for creatives to take advantage of this, and it is imperative that, you know, creatives seek this benefit for their, you know, creative and monetary investments. So some of the objectives of this session, we're going to look at 3 areas of intellectual property, being copyright, trademark, and patent. We're going to look at the benefits of these rights. We're going to look at the registration process of these IP rights. Then we're going to look at some potential, you know, streams of revenue for a creative, you know, by registering and taking advantage of these IP rights. And then we're going to look briefly at how being registered or registering these rights, you know, helps in the case of infringement or counterfeiting of these intellectual rights. So types of intellectual property protection available to creatives. And we're just going to start off with a quote. Millions of people toil in the shadow of the law we make, and much of their livelihood is made possible by the existence of intellectual property rights. And this is a quote from Alex Kozinski, a former US appeals court judge. And basically he's saying that, you know, intellectual property rights and, you know, the ability of these property rights to protect people, they can feel more comfortable, you know, creating their works, toiling, you know, and creating their works, and the law protects them and they can feel comfortable in this fact. So we're also going to start off, and I'll be using a case study throughout the presentation, just to kind of give a practical look at how everything I'll be speaking about applies. So case study. Mary is a photographer who takes the most breathtaking photos of landscapes, and she earns her living by selling these photos. Recently, Mary established a small business, Mary's Photos, and she also designed an intricate logo with an interlocking M and P, which she uses on all her packaging. Does Mary have any IP rights here that she should protect? Well, let's find out. So types of intellectual property, as I said, we're going to start off with copyright. Copyright is governed by the Copyright Act, and copyright vests once a person has created an original work from the protected categories of works. And these are literary, dramatic, artistic, and musical works, typographical arrangements. There are a couple others, but these are the main types. And basically, what this automatic vesting means. As soon as you create this work, you have copyright in the work. So normally when an author creates a work, they're also the first owner of the work and the copyright in it. Now, there are different situations where this may not entirely be the situation, for example, where you contract somebody to do work for you in an independent contractor situation. That person is actually the owner of the copyright in the work. So you have to be very, very careful to, be clear as to who owns the copyright in work. Copyright may be registered at the Jamaica Intellectual Property Office, JIPO. And we are suggesting that you definitely do a registration, and we're going to get into why, but it's very important that you register your copyright at JIPO. And it is a voluntary registration system. And basically how you go about registering is you complete a registration form, which is going to request certain information like the title of the work, the description of the work, date of publication, all of the author's details, their name, address, that sort of details. And then it's also going to ask about the nature and duration of the rights. There will also be a declaration of authorship, which basically is going to be the creative saying, I am the author of this work, I am the owner of the copyright in the work. Trademarks are governed by the Trademark Act, and a trademark is any sign which is capable of being graphically represented and capable of distinguishing the goods and services of one undertaking from those of another undertaking. Basically, all this means is that I have my mark on my package over here, John has his mark on his package over here, and because they're different marks, people know that these goods belong to me and these goods belong to John. Registration of a trademark grants to the proprietor of the mark all the rights and remedies and entitlements under the Trademark Act. In order to be eligible, however, for registration or protection under the Trademark Act, a trademark must not be one which is disqualified from protection. And basically, examples of trademarks which might be disqualified are those which are contrary to public policy, those which are deceptive as to the nature. So if I put something on my packaging and it makes it seem like it comes from somewhere that it doesn't, that would not be protected. Protected emblems like the Jamaican flag or the other emblems, trademarks which are prohibited by law or made in bad faith, or those which disparage any institution or person, whether alive or dead. To complete a trademark registration at JIPO, a creative would complete a TM1 trademark registration form. And this form is gonna ask for certain information again. So it's going to ask for the representation of the mark, whether it's a word mark or it's a logo. If it's a logo, you would actually put the logo on the form. If it's a word mark, you just put the word on the form. It will also ask if any priority is being claimed on the basis of any other trademark application elsewhere. It will also ask for the specification of the goods and services. Now, this part is one of the most important parts. The trademarks fall into different classes, and this is under the NIS classification. And it's very important to be very specific in setting out the goods and services that you want in any particular class, because JIPO does not accept class headings. So you'd really have to be very specific in setting out the goods and services that you want your mark to apply to. And it's important that you seek assistance for this if you're unsure in any way of the goods and services and the classes that you might want to register your mark in. The application form will also ask for the full details of the applicant. Jamaica has also recently signed on to the Madrid Protocol, and it's been in the news quite a bit because the amendments to the Trademark Act were passed recently to basically allow for the accession to the Madrid Protocol. And basically what this protocol will allow us to do is that you could do one application and register your mark in several member states of your choice. It allows for multiple registration in different Madrid Protocol member countries. This is, however, not in force as yet, and we're not particularly sure of the timeline, but you can just keep abreast of what's happening. I'm sure it will be in the news. Patents are governed. Well, in 2020, the Patents and Design Act was passed, which is meant to be the new act. However, this is not yet in force, and therefore patent applications in Jamaica are still operating under the provisions of the 1857 Patent Act, which we will refer to as the old act. A patent is a monopoly granted to an inventor to use his or her invention. Under the old act, a patent would have been valid for 14 years, and with the possibility of a 7-year extension. And now it will be valid for 20 years when the new act comes into force. Under the old act, a patent required an invention, discovery, or improvement. So basically, any manner of new manufacture or mode of manufacture. Under the new act, an invention is only patentable if it is new. It needs to involve an inventive step, and it has to be capable of industrial application and not excluded from patentability, similar to trademarks. So categories of goods or categories of things which are not patentable include plants and animals, plants and seeds, mathematical methods, rules, methods for performing mental acts, doing business, playing a game, or a computer program. Under the old act, there was no priority. So similar to trademarks, there are no priority applications. When the new act comes into force, there will be the availability of a priority date for patents based on an application for a patent in another country. Under the new act, perhaps one of the greatest benefits is we will now be a part of the PCT, which is a Patent Corporation Treaty. And this, similar to the Madrid Protocol, will allow an applicant to file an international patent application and basically facilitate, simultaneous applications in, the different PCT states. So the application process for a patent, which is, under the old act, which is still operating, you would submit to JIPO a petition, a declaration and specification in duplicate and form of letters patent. Petition is basically a petition to the Governor General asking for the grant of the patent. The declaration would set out that to the best of the patentees or the applicant's belief, he or she's the first creator or first inventor of the patent. And then the specification will go into details of the patent, its usefulness, its objectives, and if the usefulness and objective would be better shown by a model, then the model should also be included. And then basically the form of letters patent is what the Governor General would sign once he receives notice that all the formalities have been met. So once you send these documents to JIPO and JIPO is okay with the formalities regarding this, they'll send over all the documents to the Attorney General's chambers. And if the patent has actually been granted in another country, it would be wise and is usually asked that you submit the foreign grant so that the foreign grant can be used as a basis for granting the patent in Jamaica. And this is where we're from a jurisdiction where there has been extensive assessment. So patents, if the application is found to have met the required criteria at the Attorney General's chambers, the Attorney General will advise the Governor General and recommend the grant of the patent. the Governor General will then sign the form of letters patent and grant the inventor the monopoly rights. Under the new act, however, a patent application will be filed at JIPO, who will be responsible for the application from start to finish. So from your submitting it to the grant of the patent. And the new act would see the applicant completing a Form 1, which should be accompanied by a grant of patent, a specification, and an abstract. And basically, a grant of patent is similar to the petition, and it will set out the name of the applicant, will set out the name of the invention. The specification will give the details, again, similar to the old form, and then the abstract will basically set out the technical information on the patent. So, does Mary have any IP rights she should protect? Well, I think we've seen that, yes, Mary should definitely register her copyright in her photos at JIPO, and where she's come up with this wonderful, intricate design for her logo, she should also do a registration at JIPO to register her trademark. Now we're going to look at some of the benefits of copyright, trademarks, and patents, because there's no real interest in them unless you're going to get a benefit from them. So we're going to take a look at Mary's continued story. So Mary has continued to take photographs and sell her art. She's approached by a lady on social media who is interested in using one of Mary's photos on some shirts in a new fashion collection. The lady has fallen in love with Mary's photos, and has stated that she's willing to do anything it takes to have the photos on her shirts. How can Mary benefit from this? We're going to take a look now. So, benefits of copyright, trademarks, and patents. Copyright grants exclusive rights, including the rights to copy the work, to issue copies of the work to the public, to perform the work, to play the work, and to broadcast the work. So these are exclusive rights which are granted to the copyright holder. Trademarks also grant, exclusive rights in the mark for the use in Jamaica or wherever it is registered. And for patents, similarly again, registration confers on the patentee, certain exclusive rights, including the right to exploit the patent, to prevent others from exploiting the patent without consent, and authorizing others to exploit the invention. Where the copyright holder has these exclusive rights, they can capitalize on these rights by granting to third parties, the right to use the work in certain ways. So you could do an assignment of the rights or a license. Similarly, with trademarks, you have these exclusive rights, so you can enter into assignment agreements or licensing agreements. And the same is in relation to patents. You can, you can pass along these exclusive rights or pass along parts of the rights, which, then the patentee would be able to get some sort of lucrative, arrangement, can enter into a lucrative arrangement in relation to those rights. Now, it is very important, and this is important when you're doing anything in relation to the work or the mark or the invention. It must be registered, because registration is basically incontrovertible proof that this work is yours, the mark is yours, or the invention is yours. And when you can make this stand that these rights belong to you, then a creative can more confidently, deal and exploit in his or her work. So, show me the money. Important considerations for when granting assignments and licenses as a potential revenue stream. Now, this is, I think, probably the most important part, because you want to know, when I register my copyright, you've seen the benefits, what can I do with it that will be beneficial to me monetarily and in any other way. So some important considerations when doing an assignment or a license, you have to look at who are the parties involved, what is being assigned or what is being licensed, you know, and most sort of importantly, what are the rights, what is the duration, and what is the value that you are going to get from doing an assignment or a license. So with copyright, and we're going to start with assignments first in each of the IP rights and then move on to licenses. So for copyright, an assignment must be in writing, executed by or on the behalf of the assignment. And an assignment may be for all the rights of the copyright. So it may be the right to just copy or the right to just broadcast, or it may be for all of the rights. And, you know, a creative must be very sure to look at the terms of the assignment and make sure that they are getting value from this assignment. For licenses are not required to be in writing, but it is extremely prudent. And I would basically say, never give a license that is not in writing. So it should be in writing and must clearly set out the terms, because you want to make sure that everybody understands and is on the same page. I would definitely recommend that anything that you're doing in relation to exploiting your rights, including a license, you put it in writing. Licensings bind every successor in title of the copyright, except a bona fide purchaser in good faith for valuable consideration. This basically means that, you know, licenses bind everybody who comes even after the transaction has happened, except a person who, you know, has given, you know, some value and had no idea that the license exists. But, you know, in a situation, you know, it binds everybody else. So for assignments and licenses, creatives can also do what is referred to an exclusive license, where the licensee, therefore, is the only person who can do the work in relation or do anything in relation to the work. And this is not exercisable against the copyright holder, who, you know, can also do those acts. But it's important that you realize that when you grant an exclusive license, you know, the licensee is now entitled to all the rights and remedies in relation to the act, just as if there had been an assignment. So a creative must exercise all due care when entering into a license agreement and ensure that the grant of such a license makes practical business sense and would be profitable. So now for assignments of trademarks. An assignment of a trademark must also be in writing, executed by or on the behalf of the proprietor of the mark. And in the case of a company, this requirement is satisfied by affixing the seal. An assignment of a trademark may be, you know, in whole or limited to certain circumstances. For example, if you have a trademark registered in, you know, 4 classes, an assignment can be for 2 classes, or an assignment can be for 1 class, or, you know, in relation to certain goods and services, in relation to all of the goods and services that are registered. And it may also be, you know, limited depending on the location. So when a trademark assignment is done, it may actually not be done where, you know, there would be any sort of deception or confusion by the public. So if I assign a trademark to you and you're in a particular location where somebody has a similar trademark and it's going to cause some sort of confusion, then that would not be accepted. So as with copyright, you know, it's necessary for you to ensure that the terms of the assignment would be beneficial. Licenses for trademarks, you know, must be in writing. This one specifies that it must be in writing and, you know, signed on behalf of the, for or on behalf of the licensor, meaning the person giving the license. This may also be limited or general, and licenses bind the successors of a licensor. So again, it continues beyond the transaction. As with copyright, you know, a license, exclusive licensee has all the rights and remedies in relation to the license as if there has been an assignment, and this runs concurrent with the creative's rights and remedies. Therefore, it's important to do a risk analysis, benefit analysis to ensure that when you're licensing your trademark, it's worthwhile taking into account what the benefit to you is going to be in terms of any monetary or other benefits. An assignment of patents must be in writing, as with copyright and trademark, and the assignment will actually be void if it is not in writing and signed by or on behalf of the assigner. Where an assignment is made, it may be for the patent, certain rights in the patent, and this can also be done for an application for a patent, assign an application for a patent. The holder of a patent may also grant a license to work the invention to which the patent relates. And the terms and conditions of any license should be very clear. And if, for example, the license is, going to allow a sub-license, it should specifically state so. Because licenses and sub-licenses may be assigned in the same way, and they vest in the same way as property, or personal property. Now, where there is an assignment of a license, this has effect only if the assignment or license is registered. So for this one, you have to register the assignment or the license. And, as with trademarks, as with copyright, you have to make sure that when you are doing an assignment or a license of a patent, that it makes practical business sense and would be, valuable and profitable to you as a creative. So what can Mary do in relation to the proposal for the photos to appear on the shirts? So Mary would have to look at the feasibility of the venture. She may wish to grant a license, and she may wish to grant, a limited license so that the photo can only be used on the shirt. And, she would really have to make sure that when she looks at it, she sets it out in writing, and that this document in writing will set out, what is the benefit to her, definitely set out what is being licensed and what is the benefits to her, monetary or otherwise. Now let's take a look sort of briefly at infringement and counterfeiting, because the thing is that when you put your work out into the public, or you put your invention into the public, or you put your trademark into the public, the truth of the matter is that there are some unscrupulous people who will try to take advantage of, these marks, these inventions, these works without your consent, and try to gain a benefit for themselves, sometimes at your expense. So it is important for there to be registration. I'm going to look at why registration is so important in the cases of infringement and counterfeiting. So part 3 of the case study. Despite only having recently started business, Mary, while out, passes a storefront and sees a book in the window with one of her photos on the cover. Mary did not, however, give permission to anyone to use her photo on the book cover. We're going to look at what issues arise here and whether Mary has any recourse. So, infringement of copyright. In order to establish infringement of copyright, a creative would need to show that a third party who is unauthorized is doing any of the following acts, which is importing an article which is known or believed to be an infringing copy, possessing in the course of their business, selling, letting, or offering, or exhibiting in public an infringing copy, or where a person, has in their business any sort of, article which can make infringing copy, or if they reasonably believe that such an article can be used to make an infringing copy. Where there has been copyright infringement, there is recourse which is available to a creative, and this includes court action. So you can file a court action for an injunction, or you can file for damages or an account of profit, which is basically where, you know, you see what the person has made by your copyright, and then, you know, that would be awarded to you. And a creative may also seek an order for delivery of, which basically means, you know, they're gonna give you the infringing copies or any article which is capable of making those infringing copies. The statutory penalties, which means the penalties under the Copyright Act for infringement, is a fine of 50,000 or a term of imprisonment for a term not exceeding 1 year, or both. And this is where you are, you know, convicted in a summary court or a parish court. And the fine for conviction in a circuit court is a term of, you know, fine or term of imprisonment not exceeding 3 years, or both. However, to access this recourse, a creative would need to show that they have standing, meaning that they have a right to bring this action. And this is where registration becomes really important, because by registering, you can show, you will have some sort of proof that this is your work. So you do so you can prove that you do have the right to bring this action. For trademark infringement, a creative may show that his trademark is his or her trademark is infringed when an unauthorized third party in their business uses a sign which has the following relation to the creative's trademark. So where the third party's sign is identical to the trademark for identical goods or services, or it's identical to the creative's trademark for similar goods or services, or it's similar to the creative's trademark for identical or similar goods and services, or where it's identical or similar to the creative's trademark and the goods are dissimilar, but the mark takes an unfair advantage or is detrimental to the reputation or character of the creative's marks. So where any of those situations occur, you know, there is an infringement of a trademark. There is also recourse, which is available to a creative for trademark infringement, and it's basically very similar to copyright. So there is, you know, injunction or damages, delivery up of infringing goods, and you can also get this, you know, the items destroyed or forfeited. And the statutory penalties under the Trademark Act, you know, are a little more robust. And it is a maximum fine of 1 million Jamaican dollars or a term of imprisonment of 1 year on conviction before a parish court. And on conviction before a circuit court, the punishment is a fine or a term of imprisonment not exceeding 5 years or both. As with copyright, to access this recourse, you would need to show that you have standing, and this will be proved by showing that you are the registered proprietor of the mark. For patents, an infringement of a patent is also, you know, shown where a third party who is unauthorized in relation to a patent that's in force in Jamaica has done any of the following acts: where the patent is a product, if they have made, disposed of, or offered, or used, or kept it, or where the, you know, patent is an invention, where the invention is a process, where the person is using or offering to use the process in Jamaica, and or it would be obvious to this person that they are doing this without the consent of the owner, or where they are disposing of, offering to dispose of, using or importing any product obtained directly by means of that process, or is keeping that product, whether for disposal or otherwise. A patent is also infringed where a person supplies or offers to supply to another person who is not a licensee any means which is essential, which is an essential element to the process for the purpose of putting the invention into effect in Jamaica, where this person knows, or it should be obvious to this person, that, you know, these means were suitable or were intended to be put, or to put the invention into effect in Jamaica. So similarly, as in trademarks and copyright, a patentee may bring an action in court for injunction, damages, account of profit, or, you know, delivery of or destruction of any infringing product. A patentee may also seek a declaration, basically to say that the patent is valid and has been infringed by this unauthorized third party. A person who falsely represents that he or she is the patentee of an invention actually commits an offense under the, and these infringements would be what would come under the new Patent Act. So under the new Patent Act, this person would be liable on conviction before a parish court for a fine not exceeding 500,000 or a term of imprisonment not exceeding 6 months. And again, you have to register your patent, because it is evidence that this patent belongs to you, this invention belongs to you, which would help you in a claim against an unauthorized third party who is using your work or your invention without your consent. Now, counterfeiting is another big issue. And then counterfeiting comes up a lot in relation to trademarks and patents. So basically, counterfeiting is a huge problem, because what happens is that there is a similarity between the counterfeit good and the genuine one, which causes confusion. And when there is confusion, it can cause actually reduced sales, fear of prospective consumers that the goods that they're getting, you know, is counterfeit. And this can actually cause actual loss to the creative, because their goods are no longer scarce, and scarcity would have driven a higher price. But if there's, you know, the market is flooded with, you know, counterfeit goods, then, you know, the value of your actual genuine product does go down. So counterfeiting basically dilutes or waters down the effectiveness of a well-known trademark. And this is really challenging, where creatives invest heavily and the counterfeiter starts using this sign, which is identical or similar to their registered trademark. And the counterfeit goods actually takes an unfair advantage of, or is detrimental to, the distinctive character and reputation of the mark. And this is particularly important in the case of, you know, counterfeit health products, or counterfeit airline parts, or counterfeit car parts, where actually, you know, this is not only an infringement of your rights in relation to your marks, but it's actually dangerous. So in relation to public health, in health products and other products, these can cause irreparable damage, where the product is inferior, ineffective, or, as I said, actually dangerous. So when you have health products that, you know, say that they're going to do something, and then the counterfeiter has made an inferior, ineffective version of this product, and actually it causes harm to the person who uses it. Creatives, therefore, must be very vigilant and police their marks and their patents in order to ensure that they're not being used in an unauthorized way, and because this can affect their reputation and affect them negatively in terms of bottom line. So does Mary have any recourse in relation to her photo that's being used on the book? The answer is yes. So where Mary would have registered her copyright in the photo, she would be able to show that, you know, she has standing to bring a claim, and then she could bring a claim against, you know, the person who has utilized this work. And she can show, because she has the benefits of being the person who has the exclusive rights in relation to this work. So this person would then be open or can face legal repercussions for using her mark or using her photo without her consent. So we're wrapping up now, so let's review some concepts. Intellectual property is a must for creatives who put all this time and effort into creating their marks, their works, and their inventions. And we've looked at some of the immense benefits of it, and we've looked at, how you get protection and how by these, by these benefits and the remedies that are available to you, you can actually prevent unauthorized third parties from using your work or your mark or your invention. And therefore, there's really nothing to be lost by doing registration. I mean, if anything, there are only benefits from doing registration. So it's also important that you realize that when you have this registration, there is, different streams of income for you as a creative, because you can more confidently, explore your work. So you can do these through, as we mentioned, assignments or licenses. So I think that it's really very important for creatives to take a look at all the benefits of intellectual property protection,